Assalamualaikum warahmatullahi taala wabarakatuh. Assalamualaikum warahmatullahi taala wabarakatuh. Good afternoon, everyone. We will continue our lecture. Today, I will share with you the topic of company secretary. Let me share with you my slide. Okay. Okay. So now, what we will learn is we will learn about the nature of the company secretary duties. Okay, which is the duty are varies, is different according to the needs of the company, right? According to the needs of the company. So, basically, in earlier time, if we refer to the record, the company secretary regarded as not important person, law status and authority. They are regarded as clerical and ministerial, and it's just like a mere servant of a company. Well, actually, it's not like that, right? They have a very important role, right? Most of the time, the company directors, members, they will instruct the company secretary to do certain works, right? And then, so the earlier time is not holding the similar view with this present time. Okay. Now look at this. We have Malaysian Association of Company Secretaries. Currently, the company secretary, they hold a very important role and very significant responsibility and influence, and they are regarded as the company's chief administration officer, OAD, right? This is a judgment of a judgment in the case of Panorama Development, Guildford Limited, and Fidelis Furnishing Fabric Limited. Okay. So basically, in the judgment, it stated that the company secretary is an officer of the company, right? They have an extensive duties and responsibility, and this is not appear only in the Modern Companies Act, but also by the role which the company secretary plays day-to-day business of the company, right? Company secretary is not a mere clerk, right? He regularly makes representation on behalf of the company and enters into contract on behalf of the company, which come within the day-to-day running of the company's business. Okay, so sometimes when we cannot get the directors, we want to send document, we send to the company secretary, right? And company secretary in current time, company secretaries here, they entitled to sign contract connected with the administrative side of the company's affair, such as to employ staff, order car, and others, right? Now we need to know why the company need a secretary. Why a company need a secretary? Directors, it seems that they do not know, or shall I say that not necessarily all directors know all the matters relating to the company, especially the technical matters, like when to hold AGM. You know, it is the duty of the company secretary to remind the directors, to remind the company, and then to issue notice calling for AGM, right? They will remind like, look, directors, you haven't hold your AGM. It must be held within this time and this time, okay? And also like documentation for the submission to SSM or Registrar of Companies, yeah? And then the preparation of the minute of meeting, the report of the meeting, allotment of shares documentation. Allotment of shares documentation is done by the company secretary and sometimes by the lawyers of the company, yeah? Issuance of share documents and application for licensing, right? So the company will basically, the directors will basically call the company secretary and let them know what they want to do further and then instruct the company secretary to proceed. We want to do this, this, this. Why don't you do what is necessary? So the company secretary will do that, okay? And I would like to share with you this, yeah? Company secretary attributes, you see, I took it from internet, right? They are basically governance expertise, yeah? An eye for details, effective communication, because they're dealing with this. They know who to call in SSM. If they need lawyers, they know the company lawyers, and then who to speak to, right? And then LHDN, income tax, yeah? Who to deal, which department, what form. They are well versed of this, right? It has their fingertips, right? And then integrity and independence and commitment, yeah? They have integrity, they do not cheat, and then they give full commitment to the company, all right? And they also have the knowledge of organization. They have organizational knowledge, planning skills, and solid judgment. That are those are the attributes of company secretary. Now, who is qualified to be company secretary? Okay. I need you to refer to your Companies Act, section 235, subsection 1, right? The act, that particular section states that a company must have at least one secretary, right? And who can be the secretary? It must be a natural person, right? That natural person must is of 18 years old and above, and a citizen or permanent resident of Malaysia, right? This is what prescribed by section 235, subsection 1. So, you see, this is a statutory requirement that each company need to have one secretary. It is a statutory requirement. Which statute? The Companies Act. Which provision? Section 235, subsection 1. So all company must have at least one secretary. Big company, huge company, they can have, normally they have more than one company secretary. Okay, not only one, they have more than one company secretary. Okay. Can the companies hire secretary from another company? Yes, right? For big corporation, to hire secretary from another company, especially the firm that provide corporate secretary service, is normal. It's normal for a big firm, huge big corporation, to hire a corporate secretary service. They can have in-house secretary. They can also have outside secretary, right? For example, we have Ernst and Young, right? All the company. Okay. Now we will talk about licensing, section 255, subsection 2. Okay, so this section provides for licensing, right? In order to become a secretary, right? You don't go to the company and apply from the company. but you need a license from the registrar of the company. Once you become licensed company secretary, then only you go and apply. I mean, you can offer your services to the company if they want to appoint you as their company secretary. Okay. For a person who is a member of professional bodies, uh, a person who is a member of professional bodies, they do not have to apply for license, right? They don't have to, right? They just let their professional bodies knows that they wanted to practice as company secretary. Let's just see the professional bodies list, right? Now, the first one that I have here is MACSA, Malaysian Association of the Institute of Chartered Secretaries and Administration, Malaysia. So if you are a member of MACSA, you don't need to apply for license anymore from Registrar of Companies, all right? MIA, Malaysian Institute of Accountants. This is very related to you, right? Let's say that one day after graduation, you become the member of MIA. So you have to know that if you want to practice as company secretary, you do not have to go and get license for registrar of companies, but you will follow MIA instruction of procedures. Malaysian Bar Council, Malaysian Association of Company Secretaries, MAX, Malaysian Institute of Certified Public Accountants, MIPA, Sabah Law Association, Advocates Association of Sarawak. So Malaysian Bar Council, for example, when I was a practicing lawyer, let's say that I wanted to become a company secretary as well. So what I need to do is I need to write to Bar Council and then let them know about my intention to practice as company secretary. If I practice as company secretary, I have to follow all the procedures, right? So whatever procedures I need to follow, I will do that. Whatever duty of company secretaries, so I need to do, all right? It's not just my duty as lawyer, but also my duty of as company secretary. So if you are an accountant, let's say in future you are an accountant, you want to be a company secretary as well, you can, right? No need to apply a license from CCM, right? And for a company secretary, right, they have this practicing certificate. Practicing certificate is provided, this requirement is provided by Section 241 of the Companies Act. Okay. Now we have Companies Act 2016 that introduces new regulation for secretaries. Okay. Although the secretary is a member of professional body or they have license by ROC, Registrar of Companies, the secretary needs to apply for practicing certificate from ROC. Okay. So previously you don't have to. Now under Companies Act 2016, you need to go to ROC, Registrar of Companies. It is in CCM as well, all right? And then apply for practicing certificate. Right. Now, as I said earlier you don't have to, but now after the amendment, you need to apply for practicing certificate, right? So this is what Section 241 Companies Act 2016 provide, right? Previously, there's no such section, no such provision in Companies Act. Now, after the amendment 2016, the Act has been amended, and then they brought in these terms, which means that if you are a member of MIA, what you have to do is you go to ROC and apply for practicing certificate from ROC to be a company secretary. Then you might have this question in your mind. What about just now you said that, doctor, we don't have to? Yeah, under the old law, you do not need to, but under this current act, under this Companies Act 2016, you have. Okay, who says that? Section 241. Why does it happen this way? Because they have the objective of introduction of this section. What is the objective of this? Right? They want to allow ROC to have the database and information of the company secretaries, right? Previously, if I just tell Bar Council, the Bar Council would have the data, but ROC would not have the data, right? Now, to allow ROC to have all the database and information of company secretary. Whoever practice of company secretary, the ROC will know, okay? And then, why we do this? Because we do not want the company secretary who does not register with ROC earlier under the previous law, they just tell their professional body, right? They inform the professional body, right? So the professional body will care for that, all right? But now, what they want to do is by the introduction of section 241, they want ROC to have the database of all the company secretaries, and also ROC will monitor the professionalism of the company secretaries. Previously, if I go to Bar Council have the data, Bar Council will control me. But now, ROC has no control over me. Why? Because I just tell Bar Council. Under the new law, section 241, right? I have to register with ROC. ROC will give me practicing cert, right? So now ROC can control me, right? They need to control. They want to have a very professional company secretaries. And to avoid any issue relating to company secretaries' duties and responsibility. Can a director becomes a secretary? Okay. You see, a person can be a director and also at the same time become the secretary. So to have dual position, yes, they can, right? However, we have to take note. Dual position is not allowed if a task requires action from both director and secretary at the same time, right? So another secretary is needed to perform such tasks. Section 241 talk about certificate, practicing certificate. Why? To allow ROC to have database and also to allow the ROC to maintain the professionalism of company secretary. Section 242 here, right? It says that, okay, if the director want to be company secretary, you can be both. But when it comes to duty of that particular director, okay, I make an example. I'm a director, right? I also register myself as company secretary of the company. But then the the activity actually involve me as the director. I need to sign the signature as a director. So if I need to sign the document as signature of director, I cannot at the same time sign also on behalf of my another position, company secretary. Okay. When I need to sign, it deal with my position as director. I cannot be company secretary. The company need or I need to ask another company secretary to play the role of company secretary in that particular dealings or activity, right? Right. For example, we need signature of director and signature of secretary. So I cannot be signing both. All right. I will sign on part of a director or on part of the secretary only. All right. I hope this is clear. Right. And disqualification of secretaries. Right. This is, I guess, that a third time that you see the word of disqualification, isn't it? Right. Section 238 provides for disqualification of secretaries. Okay. When a secretary could be disqualified, right? The secretary could be disqualified when he or she becomes undischarged bankrupt, right? Undischarged bankrupt. This is not the first time you heard undischarged bankrupt, right? When a person being declared bankrupt, right? That is undischarged bankrupt. You know, a person when they have been declared bankrupt, they can settle all the loan and discharge themselves. So, right? Then they are not bankrupt anymore, right? Now, number two, convicted for offences in section 189. 198, right? What kind of offenses is that? Okay, section 198 talks about offenses related to bribery, fraud, dishonesty, right? It also related to management of company, such as misappropriation of corporate asset. All right. So basically, it talk about mismanagement of the company asset, right? And then number 3, the practicing certificate has been expired. So that practicing certificate has duration, yeah, and upon expiry, you have to renew the certificate. Like Bar Council, Malaysian Bar Council, all the lawyers, we have certificate, practicing cert, right? Each year, we will renew the practicing cert. I guess that it is similar with accountant as well, right? So now, although a secretary has been disqualified, he can still continue practicing with the approval of court, right? Let's say that something happened, all right, and an event occurred that make him disqualified, but with the approval of the court, he can proceed to be company secretary of the secretary of the company. Okay, we have here duties of company secretary, all right. So there are 3 main statutory duties of company secretary. The first one is to manage registration of members. The second one is to manage submission of document to ROC. All the document that needed to be submit to ROC, right? That's the duty of the company secretary to care for. They have to care which document need to submit, when to submit, how to submit, what's the date, what's the expiry term, whatever. That's the duty of company secretary. And number 3 is to manage meeting, like members meeting, issued all notice to members. Okay. And right now, manage registration of members. Okay. So section 102 subsection 1 provides that the company secretary must make sure that the register of members is properly kept and maintained regularly. So it needs to be kept and maintained, right? So if the register of members is not properly kept or maintained, the secretary commits offense, right? Under section 102 subsection 2, right? When a secretary commits offense, he will be fined. If you are proven to committed that offense, you will be fined by the court. Number 2, manage submission of document. You can see the duty from the phrase itself, yeah, to manage submission of documents. So the secretary must submit following company documents to ROC. What documents? Yeah, section 58 provided that the secretary must submit to ROC the particular of the directors, managers, and secretary, right? And section 68, the company's annual returns. All documents that needed to be submitted to the ROC, SSM, PCM, right, is the duty of the company secretary to submit. Section 221, subsection 8, provides that the duty of company secretary is to manage meetings, right? So secretary need to prepare and issue the notice of meetings. The secretary need to record and prepare the minute of meeting. Okay, you issue notice and you prepare minutes of meeting and then record all the declaration of interest of the directors. This is the duty of company secretary. I would like to refer to the case of Yi Tek Pah and another and Wong Nyap Lim and another, right? I want to share with you that this case is important. So why is this case important? This case is important because is established that a company secretary can owe a duty of care to a third party. Now look here, company secretary working with the company, isn't it? If you are a company secretary of a company ABC, so you work together with that particular company, right? ABC. ABC directors will give you instruction, right? ABC directors will give you instruction. So you will deal with that, right? So, but in this case, okay, the judgment here says that a company secretary can owe a duty of care to a third party, which means not we from the company that hire you, but from a third party. Therefore, it is very crucial that the company secretary, when they perform their duty, they exercise proper skill, the skill is which is needed, required, and also proper skill and care, right? The skill that needed and required, and then uh, following the instruction here when performing their duty. Okay, and this one I got from the MalaysianLawyers.com. Okay, you may refer to MalaysianLawyers.com. Right here. Okay. In this case, what happened was the company secretary was instructed to adjudicate and stamp and register transfer of share from the registered shareholder to the beneficial owners, right? However, in the midway through the adjudication process, the registered shareholder instructed that the company secretary to stop transfer, right? And there was a dispute as to the ownership of the share. So they said proceed with transfer, and then they said wait, don't transfer. They have dispute to the ownership of the share, right? So the beneficial shareholders, right, the one who share will be transferred to, right, or the intended transferee of the shares, they brought a claim against the company secretary. They sue the company secretary. Okay. But when it goes to court, the court decided that number one, there was no claim based on contract, right? The company secretary did not have any contractual relationship in what the company secretary did not have any contractual relationship with the intended transferee of the shares. Intended transferee means the person that we intend to transfer the share to. Like he is still, the share will be transferred to him, which means that he is not the shareholder yet. He is not a member yet. His name is not in the member registry. Okay? So when a person is not a member yet, his name is not registered in the member registry, he is an outsiders, right? He is the outsiders. Outsiders, or we call it as third person, third party, right? Company secretary only bound to listen to the members or shareholders or directors or whoever from the company that paid their fee. You appoint me as your lawyer, I will listen to you. If your wife come and tell blah 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 do this, I will not listen to your wife because she is not my client. You are my client. I will listen to you, I will advise you, you pay me, right? She's not my client. Similar here, company secretary deal with this company. So the company secretary will deal with the members, shareholders, directors, all right? So in this case, the court say that, look, intended transferee, you are intended transferee. There is no contractual relationship between the company secretary and you. All right. So if you go on basis of contract, you want to sue company secretary on basis of contract, there's no contract. They are not liable. Number two, the company secretary, yes, they owe duty of care. to these intended transferee to properly carry the instruction to adjudicate, transfer, and register the share, right? So the company secretary was expected to take into account the intended transferee interest in the share. So second point is, when a company secretary want to perform their duty, they have to do it with care, right? The third, however, the court decided there was no breach of the duty, right? Right? The court say yes, the company secretary has duty of care towards the intended transferee. But the next point, the court said that, but, right, there is no breach of duty. If you sue the company secretary, the court looked at the circumstances and then decided, yes, the company secretary has duty, they breach duty, then only company secretary has to pay. But in this case, the court said, yes, there is duty of care, right? But the company secretary did not breach the duty, right? In this case, nothing suggests that the company secretary had not exercised the skill and care expected of him. So basically, in this case, the company secretary has exercised, all right, the skill and care expected from him. When we have duty of care, there are certain level of um, standard that we need to achieve to say that we have do the work with duty of care, right? So in this case, when the court looked at the circumstances, evidence and everything, evidence here and everything, the court found that the company secretary actually has done what is expected from him, right? So this case is very important, very crucial, right, to establish that a company secretary can owe duty of care to a third party. So when we say this, we have to remember all company secretary, they have to perform their duty with diligence, good faith, right? Full of care and full of skills, right? So you cannot say that just do it lah, you know, but you have to do by follow all the procedures. Okay, I guess that's all from me. Thank you very much. Assalamualaikum warahmatullahi taala wabarakatuh. Have a nice day, everyone. Bye bye.